Good morning, and thank you for joining today's Drugs Don't Work in New Jersey webinar, sponsored by the Partnership for a Drug-Free New Jersey. All participants are muted. If you have a question, please use the chat feature. We will address all questions at the end of the presentation. A recording of this webinar will be made available later today on ddw.drugfreenj.org. To get us started, I would like to introduce the Partnership for a Drug-Free New Jersey's Director of Special Events, Matt Birchenow. Matt.
Good morning, Greg, and good morning, everyone attending today. Thank you so much for joining us for today's Drugs Don't Work in New Jersey webinar titled Marijuana in the NJ Workplace, Now What? Hosted by the Partnership for a Drug-Free New Jersey. Drugs Don't Work in NJ was established to help business owners and public sector employers address the impact of substance use on the workplace by offering employers education and resources to help make workplaces drug-free, and also providing information on how to assist employees struggling with substance abuse. Now, on February 22nd, Governor Murphy signed cannabis reform bills into law, legalizing and regulating cannabis use and possession for adults 21 years and older. The full impact of the laws will not be known for some time, but we know the legalization of marijuana will affect workplaces. Today's webinar will help members of Drugs Don't Work in NJ begin to understand what the law might mean for their business and their drug-free workplace policies. We're grateful to be joined today by a panel of experts who can help guide us through the law and some of the questions we have about its impact. Brian Peet is a partner in the New York and Newark offices of Lewis Brisbois and a member of the Labor and Employment, Complex Business and Commercial Litigation, and Professional Liability Practices. He has significant experience representing businesses in employment-related matters involving discrimination, retaliation, harassment, and violations of wage and hour laws. Lauren Marcus is a shareholder at Littler Mendelson. She represents and advises employers in various aspects of employment law and regularly advises and counsels clients on a wide array of day-to-day concerns, including leaves of absence issues, wage and hour questions, and handbooks and policies. Steve Trimbley is a partner at Trimbley and Prusanowski. He specializes in labor and employment law on behalf of management, representing public and private sector employers in the full range of labor and employment law issues. Steve's practice also includes administrative law, occupational safety and health law, pension law disputes, appeals, wage and hour law, and EEO compliance. Thank you to our panelists for joining us today. We're very excited to have you, and we'll jump right into the questions. We know we have a lot of them and we have a lot to sort through. So Brian, I'll start with you. Could you just give a brief overview of what the new legislation says and how it will impact employers and their workplace drug policies?
Sure. Thanks, Matt. Good morning, everybody. Again, my name's Brian Peet, and I hope everyone can hear and see me. It's been a year of doing this, and I'm still not very good at video conference. So, as Matt mentioned, the law signed by Governor Murphy in February does contain new significant employer provisions, and I'm going to give just a kind of 30,000-foot overview of that for purposes of starting our discussion. So relevant for this morning, the law effectively creates a new, quote unquote, protected class of employee, i.e. recreational marijuana users. In broad strokes, the law prohibits an employer from taking adverse employment action, which generally means refusing to hire, refusing to employ, or refusing to promote a person solely on the basis of whether they are a recreational marijuana user. The law, as presently written, and I say presently written, that's a big qualifier because there could be a lot of changes to this over the course of the next several months, applies to all employees regardless of job classifications or duties. So currently there are no carve-outs for employees who may be in what are called safety-sensitive positions. The law does include a carve-out, which we'll discuss later, for employers who are subject to certain federal laws and federal regulations. These provisions that we're going to discuss today do not go into effect until August 21st, which is when, in theory, the Cannabis Regulatory Commission that the law created will adopt rules and regulations to address the interpretation of this. What does the law allow you to keep doing? It does allow you to continue to maintain drug-free workplace policies prohibiting the use and possession of marijuana and marijuana products during the work hours. It also continues to allow you to prohibit employees from being impaired or under the influence of marijuana in the workplace. How you go about doing that practically is something we're going to discuss later on. With respect to drug testing, overall, the law does largely gut marijuana workplace testing, really. There's no prohibition on testing, but right now you cannot refuse to hire a person or take an adverse employment action against them solely because they test positive for marijuana. Again, with the exception of those subject to certain federal regulations, such as Department of Transportation. If you do choose to take an adverse action based on a positive test, there are certain rules that govern the test. And this is where this gets a little bit more confusing, unfortunately. The test itself will have to be what's called a scientifically valid testing method, which right now we believe to be blood, urine, or saliva. And then a certified workplace impairment recognition expert, also called as a WIRE, will then have to evaluate the employee and determine if they are impaired. Right now, it is unclear who a WIRE can be, what it will take to become a WIRE, and most of that is pretty much right now left up to the regulations that the commission is going to promulgate. This potentially will make the utility of pre-employment drug testing potentially nil. Again, drug testing is not required to discipline an employee if they are impaired or otherwise not performing in the workplace. So with that, and that was this law creates a lot more questions than it does answers. So that was kind of just a brief overview. I'm going to kick it to my colleague, Lauren, who can fill in maybe anything I left out, which may take longer than I even spoke for.
No, good morning. So, Brian's right on, the new legislation impacts employers greatly. I know that we've been seeing a trend of the legalization of recreational marijuana across the country, but New Jersey was the first state, and then more recently, New York actually followed in our footsteps to actually protect the use of recreational marijuana. These other states, even California, that everyone thinks is, more liberal than New Jersey, they decriminalized or legalized recreational marijuana, but did not really impact an employer's right to act, to prohibit the use of marijuana off duty. So New Jersey's law is the first law that said, not only is this legal, not only is it not criminal, but now your off-duty use of recreational marijuana is a protected status. And so that's really a huge takeaway for employers. And this is much further than the other laws have gone. The only other thing I'd point out is technically Governor Murphy signed 3 laws on February 22nd when he kind of passed this package. One of the laws that hasn't been discussed too much actually regulates background checks and whether you can use prior convictions for various marijuana offenses when not hiring someone. So in addition to current marijuana use being protected, there's now something that employers should keep track of and make note of when you do background checks. There are certain restrictions on counting past convictions. That part of the legislation is pretty complicated. In great New Jersey fashion, we tend to just cross-reference all the criminal code and not make it easy for anyone to figure out which offenses are protected, which aren't. So, I recommend if you use a third-party vendor for background checks, just make sure they're on top of the new law, and that if you're going to deny someone an offer of employment for, something that comes up in their background check, if it has to do with marijuana, kind of make an asterisk next to it and check with counsel before you do it. Steve, do you have anything else to add? We'll kick around the table.
Just to jump in quickly, and good morning, everybody. Steve Trimbley here. To add to the complication of everything that Brian and Lauren have just explained to you, the employment protections you're going to hear about today apply to the use of so-called lawful cannabis, which is the product that is grown, developed, and marketed and sold under the highly regulated and highly taxed cannabis industry that is about to be created by the Cannabis Regulatory Commission, which has a lot of work ahead of it. It's having a meeting tomorrow night that's going to devote entirely to equity in the business which means that I don't know, and I don't know if anybody knows, what priority they're going to be giving to employment issues such as the wire regulations. However, anything purchased outside of that highly regulated system remains unlawful. In fact, here in New Jersey, we're going to have to get used to a whole new vocabulary. The lawful stuff is referred to as cannabis. The unlawful material that is not protected is going to be referred to as marijuana. And as we'll see later on, that raises a whole series of complications. To amplify a point that Brian made about cannabis use or cannabis non-use now being a protected category under law, that applies to all terms and conditions of employment, including work environment, which means we could be coming up very soon to see cases of cannabis use or cannabis non-use, hostile work environment harassment. Because if it's a protected category with respect to terms and conditions of employment, and a work environment is a term and condition of employment, that's a possible claim as well. So this is going to be very interesting going forward. It does raise more questions than answers, at least at this point. There are already several bills pending to amend aspects of the employment provisions, and we'll explore more of them as this seminar goes on.
Great. Thank you, everybody, for very thorough description of what we know and don't know right now. And that's a very helpful way to set the table for this conversation. Lauren, I'm going to have you start off with this one. What signs can an employer look for to determine whether an employee is possibly impaired as they're working?
Yeah, so as we just discussed, with the fact that you can't rely so much on the scientific testing of, for people testing positive for marijuana, and the fact that now employers really can only, well, once the law is in effect, will only be able to take action based on duty conduct, it's going to be very important. We'll discuss wires and all that down the road, but it's going to be important to really focus on someone's conduct at work and whether you have reasonable suspicion. So the typical physical signs that they say to look for: red eyes, poor muscle coordination, delayed reaction time, potentially someone who has, quick shift in mood from being really tense to being relaxed. It's very similar to other drugs. I normally, advise employers, in general, there are certain signs to look for to see if someone's impaired at work, whether it be by marijuana, alcohol, or any other drug. So, many employers use a, reasonable suspicion checklist that we have, so to speak, which allows you to mark off a variety of symptoms or signs. So if someone's speech is slurred, if they seem confused, if they're a little slow, if their mood is different than it normally is, if you see an abrupt change, if they're suddenly unusually happy, unusually paranoid, unusually anxious, unable to focus on work. One of the big things is to really pay attention to how people are performing their work. And especially in light of this new law, since it's going to be more difficult to take action based on scientific tests, you're going to want to really focus on how people are performing their job, because that's going to be a much easier way to take action against employees. It's much easier at this, or will be much easier to say, you're not performing well, so therefore we're disciplining you or terminating you, rather than sending someone for a drug test and proving that. So I think that's going to be, one of the real keys going forward, is not just what we consider the typical quote unquote signs of impairment, but also actual performance of someone's job. Steve, can you add to that a little bit?
I'm not a doctor and I really can't add medically, but I would offer this observation that once cannabis becomes legal, we can safely assume that people who really haven't used it before or haven't used it since their college days might be tempted to try it and not be as familiar with the effects of it as they would be with, say, with drink. And for example, I know that after 9 o'clock at night on a weeknight, if I have a couple of drinks, I'm probably going to be sluggish the next morning. We can assume that you're going to have employees off duty who might try cannabis for the first time or try what I am told is cannabis with higher THC concentrations than was the case back in the 1970s when I was in school, and might not appreciate that if they smoke it late at night, they're still going to have effects in the morning. So that's something to be alert for. One of the effects that we are still told marijuana about cannabis is sleepiness and impaired perception and motor skills. Obviously, that has an impact on safety-sensitive jobs, and it's going to go to a theme I think you're going to hear throughout this discussion, which is if you're interested in testing, if you want to maintain testing, ask yourself why, and is the danger of an impaired person worth some of the struggle you're going to have to go through under this new law in order to maintain a testing program. And with that, I'll throw it over to Brian.
Yeah, I think Lauren and Steve, I think both really covered it. The only thing I'll add is I think where this is ultimately going is focus on the job performance, what they're doing, and not really the why. Because when it comes to these laws, in terms of getting to the actual why, which is doing the testing, which would prove marijuana impairment, that's going to be very difficult. So if somebody appears impaired at work or otherwise not doing their job, subject them to discipline for that, regardless of what the underlying reason is, unless you have reason to believe it's a protected medical reason or some other medical issue the employee is having.
Great. No, thank you for that explanation. Just to move on here, Steve, we'll have you kick off on this one. So you go through that, you sort of identify some signs potentially, and you feel that you have a reasonable suspicion that an employee's performance is impaired as a result of cannabis use. Walk through what you would recommend, how you proceed from that point as a business owner or employer.
So a reasonable suspicion or a reasonable cause situation. First proviso is that if you are subject to federal drug testing requirements, such as an employer of employees who holds commercial driver's licenses or rail employees, this does not apply to you. You are still under a federal law obligation to conduct reasonable suspicion testing and to remove anyone who tests positive for a THC product, regardless of how New Jersey characterizes it. They must be removed from safety-sensitive functions until they go through the substance abuse professional review and return to duty process. So we are talking here about those who are not subject to that federal requirement. The initial point to bear in mind is that if you have an employee who is demonstrating reasonable cause, until the drug test takes place, you're not going to know what you're dealing with. It could be marijuana or cannabis. It could be anything else. It could be a medical condition. So that's the first question you need to ascertain is what are you dealing with? Now, we know what reasonable suspicion is in New Jersey. That law has been settled for quite some time. Personal observation of conduct, appearance, speech, or odor suggestive of impairment. Information received from a reliable source or a source that has been corroborated, suggesting drug or alcohol use, or having drugs or alcohol on the person. So now, with the new restrictions on cannabis testing, we have to figure out how to deal with those cases. Again, as the other panelists have pointed out, there is nothing that says that you can't take corrective action based solely on the reasonable suspicious conduct you are dealing with. Someone who is behaving erratically at work, someone who is behaving in an unsafe manner, can be disciplined or even terminated for that alone. In those circumstances, you might even want to bypass testing. So this way you don't end up with a positive test for lawful cannabis and run into a discrimination issue. I think that's often been forgotten. I see this in drug testing cases. I've also seen this in disability and cases where the employer suspects a disability. Why complicate a matter if the employee's conduct itself gives you a basis for taking action? If you're dealing with possession, even of lawful cannabis, the law on this point is clear. You cannot and are not required to tolerate the possession of cannabis, marijuana, or any other substance in the workplace. Corrective action can be taken for that alone. And in that case, there's really no need to test. If someone is acting erratically, and you don't want to take corrective action, there's always you always have the ability to send that person home for being unfit for duty. And if that person is consistently unfit for duty and can't produce a medical explanation for it that needs to be accommodated or can be accommodated, then that becomes a basis for corrective action as well. If you decide to test and the test produces a positive result for anything other than THC, it's no different than when it's been in the past. You could take corrective action based on that. If the test produces a positive result for THC, we once again come up with a dichotomy. Cannabis is protected, marijuana is not. But frankly, a test is not going to tell you the difference between the two. So as a practical matter, you're going to have to rely on the wire requirement once that comes into effect. Under current law, a positive test for THC will require confirmation from a wire that the person is currently impaired, which means that once the regulations come online and we know how to become a wire and where to find them, you're going to have to get them onto the scene very quickly before the effects dissipate and the wire can't make a judgment whether the person was or was not impaired. Now, there is also, if we remember the J. Koenig medical marijuana law, which has not been repealed or amended, also requires that an employee who tests positive for cannabis must be given a 3-day period in which to present documentation to demonstrate a legitimate medical reason for the use. So that requirement also comes into play. If the employee does produce a medical verification, now we have to go through a reasonable accommodation analysis because there's an underlying medical condition. The question is whether this treatment for the medication produces an undue burden in the workplace, or there is no reasonable accommodation that can be had based on the safety sensitive nature of the work they're performing. All right. At this point, some of you out there might be thinking it's not even worth asking for a THC test at all, but even there, it's not so simple. And the example that comes to mind are the clients I represent who provide services for developmentally disabled individuals who are subject to the so-called Stephen-Comines law, who must have pre-hire, random, and reasonable suspicion testing for any person who provides services or may come into contact with a developmentally disabled individual, and are required by law to take corrective action if that person is engaged in the unlawful use of controlled substances. Again, go back to the dichotomy. Cannabis is going to be lawful, marijuana is not. Those employers may have an independent obligation to follow up and do further investigation to determine whether the person who tested positive is using lawful cannabis, for example, produce receipts from a lawful cannabis licensed vendor, or whether they're using unlawful marijuana and therefore are subject to corrective action for the protection of the populations. Again, this is why individualized analysis of your particular workplace, your particular work environment is going to become critical, and you're going to have to make a balanced decision whether to continue reasonable suspicion testing for THC and to determine how best to handle that. The reason I spoke a mouthful here, and I guess I'm going to pass the baton on to Brian for any further comments.
I'll only add, I think that one of the last things Stephen mentioned is very important, which is it's going to be an individualized analysis based on your workplace. Some employers, especially those of your large employers, a significant portion of your workplace is likely already using recreational marijuana. Marijuana wasn't hard to get really before this law. And so people who wanted to smoke marijuana or use cannabis, they may already be doing so. And again, testing may just complicate this because of the wire requirement and everything else. And again, focus on just, is the employee doing their job? If they're impaired, ultimately, if they're impaired at work, they're impaired regardless of what the reason is. Testing may only just complicate this, and a bad situation, I think, for an employer to be in is going around kind of playing cannabis detective as to, who may be a little bit high versus who isn't high, or who may have smoked last night. Just focus on, I think, what your employees are doing, whether or not you believe they are doing their job, and whether or not you have a reasonable belief that they are somehow not performing or unable to perform regardless of the underlying reason. And with that, I'll pass to Lauren.
Yeah, no, I agree. You guys covered most of it. I think the bottom line is when we talked about the signs of marijuana use before, the signs are all very similar, whether you're talking about marijuana, other drugs, and other sorts of impairment. So if there's reasonable suspicion at the workplace, I think a lot of it, as Steve said, it really comes down to your business, why you're testing, what it matters. You might handle someone in an office setting who you think you have reasonable suspicion for, of being impaired, very differently than someone on a construction site who's operating machinery. There's a lot of different facts that come into play. The bottom line is that you're not allowed to be impaired at work, even under the new law. So, reasonable suspicion of any sort of impairment, you may decide to, take action, get tested. If you do decide to keep testing for marijuana for reasonable suspicion, you should probably use just the oral saliva test, a test for the past 24 hours. It will at least avoid the argument of someone saying, I got high a week ago. It definitely will help. And as you can see, this is really one of the main areas that the new law has just created a lot more questions than answers, and that the commission has its hands full in trying to address. It's really just obviously going to be a tough road. So for now, until we have those regulations, a lot of employers are just sticking with the status quo. If someone seems to be impaired at work, we don't know what they're impaired with. We don't know if it's marijuana or something else. So do what you have to do, I guess, to keep your workplace safe. But obviously, it's something we're going to be waiting for the commission to give us some guidance on how to proceed.
Great. Thanks, everybody, for that. Steve, I just want to go back to you real quickly. We're getting a lot of questions to just try to break down the difference between marijuana and cannabis. Could you just briefly break that down, what that difference is? Because we have a lot of questions. People are a little confused on that.
Right. It's simple. The cannabis is the product that is going to be grown, processed, transported, and sold through the licensed vendors who are licensed by the Cannabis Regulatory Commission under our lawful cannabis marketplace, highly regulated and taxed. Marijuana is going to be, for want of a better term, the bootleg stuff. That if you buy your product from a licensed vendor who comply with all the regulatory requirements, that is lawful, it is protected. If you buy your product from the Sinaloa drug cartel on the street corner, that's still going to be unlawful. The penalties will not be as severe as they had been previously, but it is still unlawful.
Got it. Thank you, Steve, for that. Brian, I'm just going to swing it over to you here. And we had mentioned the WIRE, or the Workplace Impairment Recognition Expert. Can you just speak a little bit more in detail about how that is going to work out in the future? Will companies be hiring such individuals? This is coming from a business owner. Do I need to train one of my employers? Will I need a WIRE on call 24/7? I know I have a few questions there, but could you just go into that a little more in depth and tell us?
Sure. Unfortunately, really who the WIRE is going to be and what it takes to become a WIRE is a bit unsettled right now. We're waiting for the commission to issue those regulations. In terms of who it's going to be and whether or not you can employ one, it's going to come down to what the requirements are to get it, how much time that takes, and how expensive that is, and how available that accreditation is. Right now, I know there are discussions to really make this similar to a type of law enforcement training, which is going to require many hours to get certified, many specific training. That's going to put it out of reach for a lot of small employers, even small to medium-sized employers. And if that's going to be the case, you're likely going to see kind of a small cottage industry of WIREs pop up who employers are going to have to engage. And then that makes it very complicated, because if you do believe someone's impaired at work and you want to utilize testing, ideally the way the law is written now, the WIRE should be there making the call that the person is impaired. But if you're not able to hire a WIRE, or say you run your own small grocery store, general store, you yourself are not able to become a WIRE, then that really kind of basically just leaves you unable to rely on any type of testing. In an ideal scenario, this would be, a few hour seminar that HR professionals, supervisors, and managers would be able to take. And therefore the same people managing the workforce and overseeing the workplace now would be able to get their wire certification. We don't yet know if that's going to be the case. That would be ideal, but it's entirely possible that because there is such a focus on really only relying on marijuana impairment when it truly is playing a role in the workplace, they may make being a wire become very, very difficult, because the idea is, you only want a quote unquote professional making this determination. And if that is the case, most companies, small to medium size, will not be hiring an individual because it won't make sense financially. Large corporations presumably will, much like some large corporations hire employee assistance professionals. People who employ thousands and tens of thousands of employees can afford to hire a wire. So right now it is a bit up in the air, and this is one of the main things that everybody should keep their ears and eyes open about, and hopefully there'll be some more clarity as these regulations start to take shape over the next couple months. With that, I'll pass it over to Lauren.
Yeah, so Brian's, said it all. Basically, the way the law is written, it says that the program to become certified is going to be provided by the Police Training Commission, which leaves the impression it's going to be a very expensive, very lengthy program. One of my colleagues worked with a group in Delaware with the Delaware Police, and their program through the police department to become recognized was so lengthy and expensive and hard to get that only like 9 people had it. So there's definitely concern about the availability and the practicality of people being able to do this. I will say one of the new laws, as we mentioned previously, there's already been quote unquote cleanup bills introduced. So one of them was introduced by Senator Sarlo, and it specifically addresses this. One of the things that it proposes is that employers with safety sensitive positions should be able to basically perform their own reasonable suspicion analysis instead of having to go through whatever this formal wire process is, or should have an easier way of getting a wire certification. So it's definitely something that's been raised as a concern and as an issue, and hopefully will be addressed going forward. Steve?
Just to add to what Brian and Lauren have already said, I am not in any way an expert in political prediction. However, there is a Sarno bill pending that would eliminate the wire as a requirement. There's a companion bill in the Assembly and also a separate bill in the Assembly that would accomplish the same thing. Senate President Sweeney already has a so-called cleanup bill of 50 pages for the cannabis bill that was just passed a few months ago that would automatically make any police officer who is certified as a drug recognition expert a wire. I think if I had to guess, I would say what's going to happen with the Cannabis Regulatory Commission depends on the political feedback and reaction to this whole wire requirement. If the employer community is sufficiently concerned about the difficulty in certifying wires, cites the Delaware example, then we might see the CRC be a little bit more open in the training requirements and making it more available to small employers, large employers, and even the HR people I know who are salivating at the thought of a new area to specialize in. Or we might even see one of these amendments pass and the wire requirement be relaxed. So I hate to keep saying this over and over again, but it depends on we're going to see what's going to happen. This whole bill was put together in a rather slapdash fashion, and we not in any way have heard the last word on any of it.
And if I could just add very quickly, New York's law doesn't have a wire requirement. And I think that's going to raise a lot of questions as New Jersey looks at this, because especially North Jersey, it's a exit 130 or whatever you want. I'm sure I upset a lot of people by defining North Jersey. They're going to ask, why am I subject to different rules for my employees in New Jersey, my employees in New York? The two economies and workplaces are fairly integrated. And I think one thing that may work in favor of kind of either getting rid of or clarifying this wire thing is the fact that New York isn't making people, and especially New York City, making people jump through currently untold number of hoops for this.
Yeah.
Great. Thank you for that very thorough walkthrough on the wire. I know we've gotten a lot of questions on that, so that was very helpful. Lauren, I'm going to have you start on this question here, and I think we've touched on it a little bit. But are there any provisions in the legislation to prohibit use off hours for certain safety sensitive positions? If you have a doctor on call or some other fireman, any sort of person who might have to come in a moment's notice, for example, what's there about that so far that we know?
So unfortunately, no. So basically, the only carve out written in the law is that if you're an employer subject to a federal contract and complying with this New Jersey law would basically create an adverse impact for you in terms of the contract, like you would lose the contract with the federal government, you can revise how you implement the law to make sure that it is consistent with federal regulations and federal law. Technically, there's not even a carve out for federal regulations, DOT. It's clearly going to happen. I think it would be appalling if a New Jersey court said it was not preempted. So I think that kind of goes, that would be very surprising, but New Jersey, as Steve said, this was kind of thrown together. It's not even included in there. New York's law has a much broader exception for state or federal regulations. New Jersey doesn't. So New Jersey didn't even carve out state regulations. If for police, if you're civil service, if there's no carve out right now for collective bargaining agreements. I know that that's one of the things that's been mentioned to the commission and in proposed legislation. I think that, for on call, there would be an argument that you are working potentially, and you cannot be impaired during that time because you could be at work at any time. But technically there's no carve out saying teachers can't test positive or police officers can't test positive. It's kind of, as of right now, just no. So hopefully the commission or the cleanup bills will kind of clean that up a little. I think that's been one of the big concerns is, some other states that have legalized recreational marijuana have set limits for if you test, with this level of THC or above, you're deemed to be under the influence right now, to at least make it that you could try to test people or try to hold people accountable without this whole wire thing. Or as of right now, there's nothing. So until there's a scientifically reliable test to show someone's currently under the influence, unless you're subject to a federal contract, they don't have an explicit carve out for you. Steve, do you want to elaborate on that?
Unfortunately, Lauren's correct. There is no carve out for safety sensitive positions. The law does say that you do not have the right to use or be under the influence during working hours. So if somebody is called in, after off-duty use, when they're called in and they're under the influence, they can be punished for that. So as a practical matter, that might be a disincentive to off-duty use, but beyond that, there is really nothing an employer can do. Although listening to the person on call, that old distinction, engaged to wait rather than waiting to be engaged, if somebody is actually being paid to be on call and getting the overtime credit for it that employees often want, then they are technically on duty and they can be required not to use or be under the influence of even lawful cannabis. So that may be an option for those who are concerned about keeping employees available, although it's a very costly one. Again, there are bills pending that would create a narrow category of safety sensitive positions, nowhere near as broad as what I understand safety sensitive work to be. So this is an area that if it's going to be amended, it's going to have to be amended through legislation. I don't think that the Cannabis Regulatory Commission can by rule grant an exemption that the legislature did not create itself. Brian, do you have any thoughts?
My only comment back on what you just said, I think this is something that's going to have to be fixed. Similar to when the ban the box laws for parental background checks started coming out, they immediately exempted certain positions, whether it be school-based, law enforcement-based. And I think that that's something that's going to have to happen here, because right now, to Steve's point, unless you're paying for true compensable on-call, which is, you are paying to restrict an employee's basically freedom to do whatever they want, to be answerable to you at any second. There's nothing you can do to prohibit their marijuana use off hours, much in the same way you can't prohibit really any other lawful conduct, because you have to remember, and again, with the cannabis distinction, but for employers, cannabis versus marijuana, I don't know how important that's going to be, because you're not going to know where your employees got it. And if somebody bought it lawfully and shared it with them, I don't believe that kind of puts it in a situation. So I think this is something that's going to have to be amended. Otherwise, it's going to be very, very confusing. But if it isn't amended, keep your eye out, much as you would that an on-call employees, went to the bar and had too many and then came back and showed up for work. You'll be able to spot that. It'll probably be harder to spot, but if somebody is very, very impaired, you should still be able to see it.
Exactly. And if I could just circle back, just to clarify, yes, if you are being paid on call, then yes, you can prevent it. If someone's on call and not being paid, exactly, you can't stop their use. But I would hope that if like a doctor was on call and getting high and got a call, they would say, no, I cannot come. And you could discipline them for not being available to come. And if they showed up somewhere high, we can discipline them for being at work at that point. But no, there's really nothing you can do if someone's off the clock and legally using recreational marijuana.
Okay, great. Thank you. Talked a little bit about testing already, and what within pre-employment testing or random testing for safety-sensitive positions, what's going to be different? How would employers proceed now in going about these things that they've been doing in certain ways for a while? Steve, do you want to just start off with that?
Yeah, once again, we get into a complicated area. If you are, again, under the federal requirement to conduct pre-employment and random testing, you're required to continue to do that and to take the actions that the federal regulations and statutes require you to take. It also raises an interesting question with respect to police officers or any other person who's required to carry a firearm as part of their job, because under federal law, it is unlawful for any user of marijuana, and the federal government does not recognize lawful cannabis, any user of marijuana to possess a firearm or ammunition. That's just one example of a federal requirement that's still going to apply, and it's going to supersede the state law. So the first step you would need to do is to determine whether your industry or categories of employees that you employ are subject to federal law requirements and continue to follow them. There's going to be little change there if that's the case. Now, it is tempting to say that pre-employment screening for THC has become useless unless it's required by federal law, federal contract, or federal funding, because you cannot take action against an applicant due to the presence of cannabinoid metabolites due to the consumption of lawful cannabis. But also interesting, the law does permit so-called pre-employment screening even for lawful cannabis under an established employer program designed to determine the use of intoxicants during prescribed work hours. This, by definition, means a screening that is going to occur at or about the time the applicant is about to begin work, and not the usual pre-employment testing that we're used to now, where somebody is tested before they begin work. And even in that case, the pre-employment screening is going to be subject to the wire requirement, which means not only do you have to get a scientifically valid test result, you need to have the certified wire determine that the impaired person is impaired. Again, as I mentioned earlier, there may be certain cases like those who serve the developmentally disabled, where you might have to actually try to distinguish between lawful cannabis and unlawful marijuana. But then again, it's, as a practical matter for most employers, the wire requirement is going to apply, and it might be in your interest simply not to ask the pre-employment screener to tell you, or during a pre-employment test, just not to be told about the THC results. Right. Keep in mind two provisions of the cannabis reform law that supposedly, that even though we have just discussed for a better part of an hour the changes that are going to take place in New Jersey law pertaining to employment. The cannabis law goes on to say that no state law pertaining to employment matters is any way to be amended or affected, which is going to raise interesting interpretation questions when there's a specific law that prohibits all forms of unlawful controlled substance use or impairment at work, and how that fits in with this broad protection now granted by the lawful cannabis law. The law also tells us that despite these limitations on our ability to test, and despite the wire requirement, and despite the fact we can't take action against applicants because of a positive THC test, the employer obligation to maintain a drug and alcohol-free workplace is not restricted or preempted in any way. So while we are limited in our ability to test, our obligation to maintain a safe workplace still continues. With respect to random testing, and the question that was posed to us prior to our program here today was whether there's an exception for safety-sensitive positions or how it will affect safety-sensitive positions. As we discussed earlier, there's no safety-sensitive exception in the law as it's currently written. The same standards apply to them that will apply to any other type of employee. Random testing is permitted, but a positive test for THC must be confirmed by the wire in order for corrective action to be taken. As I stated earlier, although technically it does not apply to unlawful marijuana, unless you personally observed the user purchase the drug from a shady character, your chances are you're going to have no way of knowing whether it's lawful cannabis or unlawful marijuana. So as a practical matter, the wire requirement applies to all positive THC tests. Employers who are subject to legal requirements to remove or send for counseling those who unlawfully use controlled substances may have an obligation to investigate further. For example, ask the employee to produce a receipt from a lawful vendor. That again is going to depend on the laws that affect your workplace. And once again, touching on what we mentioned earlier, know yourself, know why you're testing, and know what laws specifically apply to you. It's important also to remember, as I mentioned earlier, the Jake Honig law still applies. So even in the case of a confirmed positive test, you need to allow the employee 3 days to produce a legitimate medical justification for the positive result. And if one is produced, now you are in a reasonable accommodation disability discrimination analysis. Whether the use can be accommodated without imposing a threat to others or imposing an undue burden on your workplace. Once again, there is going to be, unfortunately, no one-size-fits-all requirement. These are all the considerations you're going to have to take into account. And with that, I will toss it over to Brian and see if he has any thoughts to add on this subject.
I'll add, I think, practically, if you're doing pre-employment testing for marijuana or drug use now, you likely have a reason you're doing it. You either are required to, pursuant to a state or federal law, or you're required to because of a contractual agreement you may have with a client for whom you provide services or provide employees. And the latter is going to be really an open question. But I think if you are doing pre-employment testing now, make sure, as Steve said, you know why. If it's related to a federal law, federal regulation, federal, I guess we'll call it a federal contract, or a contract with a federal agency, you should be fine, as the law does exempt. It's not 100% clear, but I would think ultimately contracting with a federal agency should cover you if that federal agency is mandating that employees on its site have to cannot be under the influence. If you're not testing now, there's probably no reason to start, because if you don't have a reason to test, you likely can't do anything with the test results anyway, practically. So, don't ask a question to which the answer is irrelevant to you. But everybody who has pre-employment testing now needs to make sure that they know why they're doing it. And if that why is not due to some federal requirement, or at least a New Jersey state law requirement, you need to take a look at whether or not that is now still a sufficient reason to do so. And that's probably a lot of industries. For example, white collar industries, our profession, my law firm, most banks, they don't test. I worked in retail, you had to get a drug test. I don't know why to work at a Best Buy you had to get a drug test, but you did. So there are industries where drug testing is the norm, largely, I think, due to preemptive disciplinary reasons. So if you're bottom line, if you're doing pre-employment testing and it's not because a federal law, a federal agency requires you to do so, you need to examine whether or not you can continue doing that. And with that, I'll pass it to Lauren.
Yeah, I'm just going to repeat one thing Brian said, because I think it's really, really important practical advice, which is, find out, it will depend when the regulations come out and if the law is amended and whether you can do anything for safety sensitive positions. But if you cannot, then you have to be very careful, I think, in pre-employment screening of asking questions you don't really want the answer to, because I think that it puts you potentially in a bad spot. So if you cannot not hire someone because they use marijuana, and you find out someone used marijuana and you're putting them in a safety sensitive position, I get that the law says you cannot not hire them, but you now have a risk at your workplace where you know that there's a possible hazard. And that's not really tolerable to most employers. And it's really a problem, I think. So I would just be, it depends how this shakes out. But if it turns out that at the end of the day, you really cannot make employment decisions based on this testing, my recommendation would be, unless you need the testing, unless there's a reason you're doing it and you can take action on it, be very careful of what information you're getting available. It's very similar to the medical marijuana. If you have to accommodate use now for recreational use, you might not want to test for it because you don't want to now get into an interactive process and know someone has an underlying medical condition or disability if you don't have to know about it, because frankly, you have to accommodate their use anyway for recreational marijuana. So just keep in mind, know your business, know what you're doing, know why you're asking the question and what you can do about it. But, I would definitely be hesitant when not necessary to get information that might just end up, causing you more problems than it's worth if you can't take action on it.
Thank you. And we're getting a lot of questions about sort of the federal angle. And I think I'll try to synthesize them all into one that I hope will be helpful. But I guess it's what is the threshold that you have to reach to consider, it being a federal matter as far as the regulation goes. For example, if somebody asks, with hospitals, would that be considered, would they fall under the federal regulations? Because obviously there are a lot of other federal aspects to what they do, even if they're not necessarily contracted with federal agency or anything like that. So what is that threshold, I guess, to kind of reach into, okay, I can follow the federal regulations when it comes to cannabis and marijuana?
Well, it's not so much a threshold as what the laws specifically say. Now,
Okay.
The state cannabis law creates an exception for anyone who has a federal contract that might be endangered or anyone who's receiving federal funding. Hospitals obviously receive federal funding, and if under their funding, under federal funding regulations, under their grant agreement, if they are required to maintain a drug-free workplace and cannot employ people who test positive for THC, then they would be exempted to the extent that they need to in order to comply with the federal contract. As I said earlier, the CDLs, which is a whole drug testing program, that's something that is spelled out by federal law. So it's not so much a threshold, it's knowing whether in your company you have a federal contract and what those conditions are, whether you are receiving federal funding and what conditions are tied to that, or whether there is a federal law that specifically requires specific forms of drug testing, including THC testing, for your employees or or given categories of employees.
Right, and if I could just piggyback, I think, one thing that is very confusing and that hopefully, some guidance might come out and clarify a bit is this law still says you cannot be under the influence at work. And most federal regulations say you cannot be under the influence at work. There's the Drug-Free Workplace Act. There are those requirements. Federal contracts or federal regulations, some require you to have a drug-free workplace that technically wouldn't be inconsistent with this law. Some require testing, like CDL licenses, DOT. So it really is going to depend, because I think that, you could have some involvement or be covered by some federal regulations that are not inconsistent with this law, in which case you will still be bound by this law. So it's really not a clear cut. It's really whether your specific situation requires testing to confirm that your employees are drug-free.
Great, thank you. And we're going to get into one more. We're just about to hit the hour here, so we're going to have one more quick question, but I just want to speak to our attendees first that we do have a poll evaluation that just popped up. Please make sure to answer all those questions before you finish up here today. But our last question and last thought to each of our panelists, and Brian, we'll start with you, is I guess just give your last final thoughts here. But for our employers who are in attendance today, what should they be doing? Now we've gotten a lot of answers today, but we also got the answers to what we don't know yet. What would you recommend how they should start to proceed in just getting things ready for what these laws will mean for them?
Sure. I would start with looking at whatever policies you have in place. If you have an employee handbook, I regularly deal with a lot of employers who get a handbook from, say, ADP or Paychex or TriNet, and it's 80 pages and nobody knows what's in it. So the first thing is take a look at that to make sure you don't have anything that's on its face conflicts with this law. If you are doing testing, like we all discussed earlier, evaluate why you're doing that testing, and then determine whether or not you're still allowed, well, not whether you're still allowed, that you still should be doing it unless you have a federal contract or any specific requirement. I would also say take a look at any employers who either are subcontractors or who primarily generate a lot of business as a subcontractor. Look at your actual contracts. For example, when the ban the box for criminal background checks passed, I had a lot of clients who were local moving companies who supplied movers to national moving companies. And they were violating the ban the box law because their contract with the national moving company said you need to pre-screen everybody. And, the answer of, well, my client or my customer makes me do it doesn't work. You're still in violation of the law. So look at your contracts if you're a subcontractor and make sure that you don't have a contract that requires you to violate this law, because that's not going to be an excuse unless it's a contract with a federal agency or a contract somehow subject to federal regulations. And I think that the other thing too is to kind of keep your eyes and ears open. There's going to be a lot of this in the press. I would, if you have employment counsel you work with, I would check with them. I would also be on the lookout for changes. Everybody should really flag the month of August and July. Hopefully we'll be getting closer to some more clarity. But right now, start looking at all your policies, look at any testing regime you have in place, and start looking at all of your contracts, including your own contracts with vendors. If you're using a contract with a vendor and you're requiring that vendor, or you have a provision in there saying the vendor needs to test its employees, you should be looking at that as well. So look at your policies, look at your vendors, and also look at what testing you're currently doing right now. And the goal, I think, would be to try to get ahead of this, to have all of whatever policies you need redone, whatever contracts you may need renegotiated, reamended, redone as well. And for those of you who operate under collective bargaining agreements, look at those collective bargaining agreements as well, because to what extent CBAs are going to be exempt, et cetera, that's going to be a whole nother thing. And keep in mind, if you do have unionized employees, you want to be very careful about doing anything that changes the terms and conditions of the unionized employee's job without collectively bargaining it, even if it's in response to this law. So end result, look at everything, basically, your testing, your contracts, your policies. And for the reason why everyone hates lawyers, laws like this that are confusing just means you should probably call or ask a lawyer or rely on your HR professionals. And lastly, if you operate in multiple states, look at the laws in other states, because you don't want to do something, if you're going to do an across the board application of a change in policy, you want to keep in mind how that may impact you in other states. With that, I'll turn it over to Lauren. Yes.
Yeah, I think that since there's so many open questions, it's very difficult to know how to proceed right now. So I completely agree. I think that issue spotting is going to be key. Know what you may have to change depending on what the commission regulations are, what might happen. I've had a lot of clients who really want that new policy right now, and it's very difficult because we don't really know what we're going to be allowed to do. So, I mean, you can have a new policy that says you can not use drugs, at work, but, you might be able to test positive. It's really just kind of sticky. I think my biggest advice is to be prepared in knowing it's coming down the pike so that when it does come out, you kind of know where to start, you know what your policies say, as Brian said, and you're ready. And for employers who are doing pre-employment testing but don't really know why, don't really have any concerns about it, to possibly consider just taking THC off that test going forward. Just if it's not serving much of a purpose, that seems to be a big first step that a lot of companies are taking to move on with this. And Steve?
All right. Just a couple of thoughts to close it since we're running a little bit over time. First, as we've said consistently, know yourself, know why you're testing, know what the costs are, know what the benefits are, know what the risks you run if you do not. And second, understand that there's, in addition to a change in the law, there's a change in the mindset. I think there are a lot of employers that adopted drug testing in the 80s and 90s because we just didn't want drug users at work. And it was a bad thing and we wanted to put an end to it. And now we have to change the way we view things, at least when it comes to a certain drug. And it is a complete sea change in how we approach it. I know that many employers in situations where there was erratic behavior with a reasonable suspicion sent the person for drug testing because they thought they were being helpful. And if the person had a drug problem, this would flag it and they have an opportunity to go to rehab. Well, helpful thoughts aren't a protection for you anymore either. Recognize the sea change, and most of all, go back and decide whether drug testing for THC is something you really need to do, and if so, in what circumstances.
Thank you so much to our panelists, and Lauren and Brian and Steve. Just a wealth of information today as we're trying to kind of get through the little uncertainty that we're facing. And I think it was immensely helpful for everybody in attendance today. So just thank you so much for your time and for providing this information. And thank you to everyone, all our participants who attended today. Drugs Don't Work in NJ and the Partnership for a Drug-Free New Jersey will continue to monitor the impacts of the legislation and what it might mean for your workplace. So for continued updates, you can access Drugs Don't Work in NJ, the toolkit, and visit ddw.drugfreenj.org. More information we know will be coming in the next several months. So just stay tuned to that, and we'll continue to help try to guide you through it. So thank you again to everybody for attending, and have a great rest of your day.
Thank you.
Thanks, everyone.
Thank you.